So now we're really going to get into that Rowley case. So Amy Rowley was a deaf child. She had hearing impairment, and she required an interpreter. Well, her parents wanted her to have an interpreter. She could lip read, and she was doing okay in class. She was actually getting passing grades, and she was in a regular gen ed class. But her parents, who were also deaf, by the way, her parents thought she should have the same opportunity her non-disabled peers have. It makes sense. If they're able to have the access to every word the teacher says, why shouldn't Amy? Especially when she can get access simply by having an interpreter there. It's really simple. We hire an interpreter. She does ASL for every word the teacher says. Boom, Amy has equal opportunity relative to those students without disabilities. And so this is what the court called the equal opportunity standard. Well, the court rejected that. They called it an unworkable standard. And so if you've ever heard at your IEP meeting, they don't say this so much anymore. They used to about 5, 6, 7 years ago. They used to say, we don't have to give your child the Cadillac of educations. That's what they're talking about. They're saying, yeah, it's not the equal opportunity. Even if we're not giving the other students the very best, we still don't have to give this disabled student the same opportunity non-disabled students have, because the Supreme Court expressly said we don't have to do that. So they rejected that equal opportunity standard. So now the state gets to come up and they tell the court what their argument is. Their argument is that FAPE, that appropriate part of FAPE, it's just aspirational, meaning we only have to do it if we feel like it. If we don't want to, the law doesn't actually say we have to. So they're basically saying it's not a requirement at all. So if the other one is a Cadillac, I look at this one as a broken down bus. It looks like it should maybe get you somewhere, but it's not functional at all. If FAPE is allowed to be just aspirational, then at any time a school could go, we don't feel like it, and now they're off the hook. So luckily, faced with these two standards, the court rejected both of them. They said, no, we're not going to adopt either of those as what appropriate means. Here's what they said. The basic floor of opportunity consists of access to specialized instruction and related services, which are individually designed to provide educational benefit to the handicapped child. So let's dissect this for a second. The basic floor of opportunity. So the very minimum a school district can do. They cannot go beyond this floor, right? The very minimum is to give specialized instruction and related service. Okay, but what does this specialized instruction and related service supposed to do? It's supposed to be individually designed to provide educational benefit. So this is the term that the districts, the circuit courts across the nation latched onto. All of the lower courts said, ooh, so appropriate means designed to provide educational benefit. So that's really what they started hanging their hat on here, was this educational benefit. That's what appropriate must mean. Well, that didn't solve our problem. What happened was now it creates what we call a circuit split. So we've got 13 circuits in the nation, and they split into 3 categories of thought as to what did educational benefit mean. Because now we think, okay, if we've got appropriate means they should receive educational benefit, how do we measure that? What is educational benefit? Some districts or some circuit courts and their lower courts latched onto that and said, oh, it means meaningful educational benefit. Others said it just means some educational benefit. And there was another, the 10th Circuit, who actually said it just means more than de minimis, which means more than nothing. So in other words, if your child started the school year not being able to identify the letter A, and after the end of kindergarten, the only thing they could do was now tell you what A is. They could point to the letter A. Guess what? That's more than nothing. That's something. All the other kids they learned the whole alphabet and some sight words, but it doesn't really matter because it doesn't have to be equal opportunity. It just has to be more than nothing. They didn't know A, now they know A. Guess what? More than de minimis. So you can see how more than de minimis might be very different from meaningful educational benefit. So you've got kiddos in the 3rd Circuit who are now being held to the standard of meaningful educational benefit, And those in the 10th Circuit just get more than nothing. So Rowley was in 1982. In 2017, it took that long, guys, 2017, 35 years before another case went to the Supreme Court where they actually said, let us help you clarify what we meant by educational benefit. Let us tell you what we think that appropriate and that educational benefit really mean. And it was a case called Endrew F, and it came from the 10th Circuit, from this more than de minimis school of thought. So Endrew, okay, so to understand what the court meant in Endrew, we're going to parallel what they said in the Rowley case versus the Endrew case. So the placement, very different. Amy Rowley was in a gen ed classroom. Endrew, on the other hand, was in a special day class. Their disabilities, very different. Amy had a hearing impairment. Endrew was severely autistic. Their disagreement was very different as well. So Amy's parents simply wanted a sign language interpreter, right? Endrew's parents said his IEP is not reasonably calculated for him to make meaningful progress. Let's look at their progress. This ends up being a big deal here, guys. Amy's progress, she was performing better than the average kid in her class. She was getting passing grades, moving from grade to grade with passing marks, and actually doing better than at least more than half of her class. Endrew, on the other hand, was in 4th grade, and his goals looked almost the same as his goals did in kindergarten. Now, a lot of you are probably thinking, boy, I've seen that on my own kid's IEP. It happens a lot, sadly, at least from my experience. But Endrew's parents said, there's no meaningful benefit here because it's pretty much the same grade, same goals in 4th grade, 3rd grade, 2nd grade, 1st grade, all the way back to kindergarten. We've been working on the same goals. How can you argue that you've been giving him educational benefit, right? So the ruling in Rowley, the court specifically said, we have evidence that Faith is satisfied that she's actually receiving educational benefit because she's moving from grade to grade. So it's not dispositive. It's not the only indicator of special education or whether they're meeting Faith, but it is a piece of evidence, and usually a very large piece of evidence, that says if you can move from grade to grade with passing marks, working on the same work that the other kids are working on without disabilities, then that's evidence that it's appropriate, right? I mean, it makes sense. If you can keep up with your non-disabled peers, then you're receiving an appropriate education. Well, we don't have the same evidence in Endrew because he's not working at those same grade levels, right? He's in 4th grade working on the same goals he was working on in kindergarten. So we can't say he moved up to 4th grade with passing marks, working on the same things his peers was working on, because he's not. So what do? This is what the court said. If achievement on grade level is not a reasonable prospect for a child, his IEP need not aim for grade level advancement, but his educational program must be appropriately ambitious in light of his circumstances. The goals may differ, but every child should have the chance to meet challenging objectives. So this was the Supreme Court in Endrew F trying to explain what they meant by educational benefit. It has to be appropriately ambitious in light of the child's circumstances. And they are supposed to have the chance to meet challenging objectives. So it's not enough to just create a goal that we know they can meet. We want to create a goal that we hope they can meet. We want it to be challenging, not something they can learn in a week, but we're going to give them a whole year to learn it, right? But we also have to keep it appropriately ambitious in light of their circumstances. So we can't reach too far, but we also don't want to reach so low that we're not making it challenging. Somewhere in the middle is appropriate. So these are really the parameters that you have. Let's see. Okay, so we have appropriately ambitious is kind of what we've ended up with, right? Through Endrew F. So we know from the original law, FAPE means, from IDEA, FAPE means an appropriate education. We know from the Rowley case that that means an educational benefit should come. If it's appropriate, they'll receive an educational benefit. And then we get further clarification in Endrew that educational benefit means appropriately ambitious. Do you see what's happening here though? We've kind of come full circle. We started with trying to determine what does the word appropriate mean. And we ended up by defining it with itself again. So there's not a real clear description in the law about what appropriate really means. But that's good and bad. So the bad part is it can be very hard for us to define. The good part is it can be very hard for us to define. If the school can't just tell you, boom, this is what appropriate is, you are part of the team that helps determine what's appropriately ambitious for your child. So that present level section, when we get to chapter 5, you're gonna hopefully gain a whole new appreciation for what that present level section does. That is where we set out our child's interests, their strengths, their weaknesses. That's where we set the tone for what we can later say, based on their present levels, is this appropriately ambitious? Is this service appropriate for that child? Is this goal appropriate for that child? We lay the foundation for that during the present level section of the IEP. That's where most of it is done. And that's what I want you to walk away from this with. I know this, we've gone in our own circle here. So you might be going, great, Jody, thanks. I still don't know anything. And that's okay. What is appropriate for your child right now, I sincerely hope it's very different from what was appropriate for them last year and what will be appropriate for them next year. And that has nothing to do with COVID. I would have said the same thing a year ago, because hopefully your child is growing, right? The demands of the kids their age change year to year, and their skill level changes from year to year. So we need to keep molding what's appropriate for our child every single year, if not in between. Okay, so I know that I've missed a lot of questions here, but I tend to lose my train of thought if I read over the questions. So if there's something extremely important and extremely on point, please speak over me and ask. Otherwise, I'll review some of these questions towards the end of class here today. Okay, so we know from these court cases that appropriately ambitious, thank goodness, is markedly more demanding than merely more than de minimis. So the Supreme Court rejected the 10th Circuit standard. The 10th Circuit, none of them can follow this more than de minimis standard anymore. They told us further that the adequacy of a given IEP turns on the unique circumstances of the child for whom it was created. So again, it's individualized based on their circumstances, and that's your job to help create a picture of what those circumstances are, so that now you're creating the boundaries for what they can call appropriate for your child. You need to be able to identify what his strengths are and what his weaknesses are, both, right? So that we can say, well, no, that's something he can do, but that's something he can't do. We'll get into that when we get to chapter 5 a lot more. So it's not a broken down school bus. It's not a Cadillac. Every child's IEP is going to be unique. It's whatever vehicle they need to carry them into the best future that they can have. But like I've said a million times here, right? It's your responsibility as an advocate to help your child's team determine what's appropriately ambitious for your child. It's your right, guys, it's your right to guide the IEP team to the very edges of those appropriately ambitious legal boundaries. Help them determine what's appropriately ambitious for your child, and then push to the very edges, right? You may not have a right to demand the best, but if it's in the realm of appropriate, now you have a right to demand that. You have a right, but you have to help them establish that it is an appropriate thing to ask for. So keep all of that in mind as we do this entire course, because we're gonna come back to appropriate over and over and over again. And even if I don't mention it, you need to be thinking that in your mind. As we're going through each section of this, think about how could I make that more appropriate for my child, or something within that realm. It all hinges on appropriate in special education law.